mobilize around literally the mobilization of shame as the instrument of advocacy of human rights. But that falls on deaf ears if so many of those in power appear to be shameless. So it begs questions. What can we do? What can we do more effectively? I remain, probably everyone, I'm sure, not only on the panel, but here remain optimists. I believe that there's no alternative, actually. But I want to draw a few attentions to the situation here in terms of Canada and the Inter-American Commission on Rights. Unfortunately, I believe the international human rights, the Inter-American human rights system remains too little known in Canada and very little understood. Those who might be aware of it don't understand its institutions, how it works, and so forth. And even those who were skeptical, and I have heard this from Canadian diplomats and others not wishing to be subjects of criticism by the institutions, are unaware of how those institutions can contribute positively. And I would like to draw a few points in that regard. The first is, I think many in Canada have been very much buoyed by the Inter-American Commission's work with regard to Indigenous peoples in Canada. I'm sure that will be a subject of further discussion. But in that regard, the time and the circumstances are better than they used to be. There is a consciousness in Canada that we have a problem here, that it's our problem, that it's a result of miscarriages of justice in the past. These need to be repaired, and that there is a way forward, but we may need help in getting there. And I think the function and the role of institutionally, like the Inter-American Commission on Human Rights, can be very, very helpful in that regard. Second of all, right now, today, just before I came here, I saw that our own union of the Association of Professors at the University of Ottawa just issued a statement with regard to academic freedom on our campus, and specifically challenges around anti-Semitism, Islamophobia, and racism, and more broadly, anti-Arab, and I'm not sure if they use the word explicitly now, I read it quickly, but also anti-Black racism, of which we've also unfortunately had very, very troubling incidents in the recent past, the last couple of years. And so I'm glad to see that, and I'm glad to see the leadership of the Inter-American Commission in this regard, both in terms of the normative development, articulating it, in which we've had a role, and I'll defer to others in that regard, but also to following up and showing how sharing expertise, comparative practices, and what those norms should mean and look like in practice. And I think we need to hear more about that. I think this is a very important moment in time. I want to mention also a couple of other areas or a couple of other elements here. One is I'm a little bit exasperated to stand here 4 or more years ago before the OAS summit in Fort Lauderdale. I had the privilege of a brief conversation with the then Foreign Minister, Chrystia Freeland, and in a side conversation in a hallway, she asked me if I had any other thoughts on anything. We were talking about something else. And I said, have you heard of the Bellum do Para Convention? And she had no idea about it, on violence, domestic violence. And she had no idea. And I said, well, you know, with Canada's feminist foreign policy, one would kind of think we'd be easily on board. And it was, you know, shocking to discover that now almost 30 years since its adoption, only Canada and the United States of America are not parties. So I drew it to her attention, and she took on board. She asked me to send her the text, and lo and behold, it was like a week later at the summit, Justin Trudeau announced the commitment of Canada to become a party. But to my knowledge, we have yet to have become a party. So this is 4 years later, all nice declarations, and I'm scratching my head of my limited hair, losing more of my limited hair. What is it that's an obstacle to Canada coming on board with a convention against domestic violence of a feminist foreign policy? I don't get it. So I think we need to do better, especially in a country where we champion the idea, or we use the rhetoric of championing the idea of rules-based international order, upholding rule of law domestically, internationally, but also a feminist foreign policy. And in that regard, the last thing I'll just mention, or this penultimate thing, Canada has yet to become a party to the American Convention on Human Rights. So the one instrument that allows us to be subject to the only intergovernmental court that we would be subject to other than the International Court of Justice, the Inter-American Court of Human Rights, we have steadfastly declined to become a party. And that's really a shame because we could not only benefit from its wisdom and its treatment and adjudication of matters, but also our participation actively and potentially a judge and so forth. My last point is about money. And I don't know what the situation is now for the Commission or the Inter-American system as a whole. I'm assuming it's usually skint. You're trying to find pennies under the table. And this is really, I have no other word than to describe it as pitiful. That countries like Canada, where we live in abundance and we have resources for what would amount to pennies in our national budget, in our foreign affairs budget, we have not stepped up in the way in which we could and should to provide. I mean, unilaterally, we could essentially bankroll the Inter-American Commission on still a pretty small budget, even a fraction of part of our own law school here would go quite far, which I'm not suggesting we do that. Although I see Professor Paré, who would probably happily spend some time helping the Inter-American Commission on some issues. Maybe we can do some secondments or something creative. But I really think it's past due that we step up and contribute, put our money where our mouth is in that regard. So those are my remarks. I think there's a lot that can be done, should be done, and I'm hoping that as a result of your visit, we will do more. That just brings me to my principal task, which was not to babble on about my own views, but to introduce our moderator for this evening, Salvador Herencia Carrasco, who is, excuse me, has been our long-serving and actually founding director of our Human Rights Clinic. He is a well-known advocate in this field with a long personal professional experience in the American human rights system, including before its various institutions. Both before he came to Canada and in his native Peru, where he was head of the Human Rights Office in the Ministry of Justice, if I recall correctly. And since he's been with us, which is now a decade or more or so, he's made tremendous contributions. He, as I mentioned, not only in terms of the Human Rights Clinic, he's now also a colleague amongst the faculty, teaching, one of the rare people in Canada who teaches on the Inter-American Human Rights System, which he has taught for many years. And I don't know if you were teaching in both languages, English and French, sort of sometimes, Frenglish. Also like to just mention that he's got enormous experience also in specific matters of bringing, for example, amicus briefs before not only the Inter-American Court of Human Rights, but also some constitutional courts and other courts within the hemisphere, and has worked a lot on in the field of business human rights, where increasingly the decisions and the elaboration of the normative framework is becoming more impactful, including Canadian institutions. So I can't think of anyone better simply to say, to be moderating this panel, anyone more knowledgeable in Canada, at least. And it's a pleasure, therefore, to invite Salvador to moderate.
Thank you very much, John. Now I understand why you asked for my mom's email address last night. So she sent you all of that information. Good job, Mom, and Merry Christmas to you too. Bye. Thank you. We don't talk about football. It's not great. But on a more serious side, welcome to everybody for joining us to this seminar, The Developments in Justice and Human Rights, Perspectives from the Inter-American Commission on Human Rights. I would also like to welcome our audience that is watching online via Zoom. Please be aware that we are providing French translation. So just use the button on the lower right and you'll be able to choose whether it's English or French. And I would like to also thank our translators for this valuable service that you're providing today. I would also like to welcome the delegation from the Executive Secretariat of the Inter-American Commission on Human Rights, whom decided to join us in this very nice and lukewarm weather that we have here in Canada in the past few days. So it is also my absolute pleasure to welcome Dr. Amanda Dale, who's a fellow of our Human Rights Research and Education Center, and Professor Penelope Simons, who is the Gordon Henderson Scholar, Chair in Human Rights of our center, and who will comment tonight following the presentation of the President of the Inter-American Commission on Human Rights, Margaret May McCullough. Commissioner May is a citizen of Jamaica. This is her second term as elected as member of the Inter-American Commission on Human Rights. But before that, between 2007 and 2012, she was also a judge of the Inter-American Court of Human Rights. And while Commissioner May was sitting at the bench, her court or her bench decided some of the most emblematic and important cases of the Inter-American Court of Human Rights regarding sexual and reproductive rights and gender-based violence. I would just like to bring to your attention to the case of Atala Rifo versus Chile, and also Radilla Pacheco versus Mexico, again, among other different institutions. So if we are now talking about the possibility of the American Convention and the Inter-American Court to address the issue of abortion, is because there was a decision of Atala Rifo almost 10 years ago, and Commissioner May was part of that bench. And for that, we really thank you for all the great challenges that are going to come, and we're going to face hopefully positive news in the very near future. So with that, those words of introduction, please, Madam President, you have the floor, and welcome to our university.
Thank you very much, Salvador. And I thank the distinguished ladies on the stage. It's a stage. Why do women always be on the, why are we always on the stage? Are we performers? Maybe so. Maybe we have to be for this world we live in. Thank you so much for your kind words. I must say, to me, it has been an honor to serve in the Inter-American system of human rights. And it's an even greater honor when I was informed by Jean Caballero and Jesus that I am the person who served longest in the system in the entire history of it. And I said, yes, I know, my age tells me so. What to do, what to do. I'm honored also to be here. I'm really thankful to be in Canada before I demit office, because for 8 years, I have been dinging the ears of your ambassadors in Washington, D.C. that we have this visit. And I'm pleased that it came to fruition before I demit office. And I'd like to say it now, at midnight on the 31st of December. Ding. And I will have control of my time again in my life, which I haven't had for a good while. But it's been such fantastic work. The Commission is an outstanding organization. You mentioned, alluded to our situation, our financial situation, and I think we perform miracles on tuppence, you know, and I think it helps us in a way, but I mustn't talk ourselves out of money, but it helps us to be more creative in our work, and we have been, which I'm very pleased about. So, to the work I'm supposed to do tonight, I am really honored to appear before you today as President of the Inter-American Commission on Human Rights. Firstly, I'd like to say a very special thank you to the University of Ottawa for facilitating this interactive dialogue and to all the panelists and attendees present today and those who are watching and hope will participate through Zoom. I am very pleased that I am heading this Inter-American Commission of Human Rights delegation on our promotional visit to Canada, which began on Monday and will extend to Thursday. A very short but highly packed visit. The Commission is carrying out this visit to strengthen its relationship with the state of Canada with the purpose of raising awareness among state and non-state actors about the Commission's work concerning principles and standards of the inter-American human rights system, particularly focusing on the rights of women, children, Indigenous people, and LGBTI persons, and other vulnerable groups. Since yesterday, we have been meeting with national and provincial government officials, as well as civil society organizations, to discuss ideas to engage. I keep on thinking this is going to fall. To discuss ideas of how to engage different actors in the inter-American human rights system. As part of this effort, we considered it paramount to conduct academic activities with Canada's universities. And it is an absolute privilege to speak to this important audience with different backgrounds of this panel calls us to elaborate on the work of the Inter-American Commission on Human Rights and to present our perspective on the current situation of human rights in the Americas. However, I would like to firstly briefly introduce the historical perspective, which I consider important to understand our work and our mandate of promoting and protecting human rights in the Americas. The Commission was created in 1959. The Commission's mandate initially focused on the preparation of studies and reports, the formulation of general recommendations to states, and the provision of advice as a consultative organ of the Organization of American States, with the authority to travel to territories of member states to conduct observation visits, the first being to the Dominican Republic in October 1961, and I'm the country rapporteur for that state. And I should say for Canada, I should have informed you of that. Yes. And at that time, the Inter-American Commission focused mainly on serious human rights violations in authoritarian contexts, considering the dictatorships in force in the region at that time. Faced with the emergency and seriousness of the human rights situation and unforeseen context, the Commission used all its resources and tools at its disposal in a creative way and continues to do so, building the mechanisms which exist today, such as the now crucial system of individual petitions and cases. The Commission continued to make use of on-site visits as one of its main mechanisms to combat massive and systematic human rights violations occurring in the continent in the 1970s and 1980s. In this way, the Inter-American Commission of Human Rights presence on the ground and defined its role as a warning voice to the international community. Also, these visits generated important changes in the human rights standards in the hemisphere and in the concrete situation of hundreds of victims, as it continues to do today in situations of human rights crises. We cannot forget to mention this fact, that the Commission's visit to Argentina in 1979 had an enormous impact, and the delegation managed to document a systematic pattern of forced disappearances there. The Commission visited clandestine detention centers there and met with dozens of detainees and was able to report all this to the international community on the systematic human rights violation which had occurred in that country during the dictatorship. And we actually have in this secretariat a survivor of that inhuman violation in way of life. They made it a way of life without any respect for who was destroyed and made to disappear, mostly in the rivers, being thrown out of helicopters at night. Age in this evolution process came with the Inter-American Commission being the first inter-American body to process individual petitions. The Inter-American system of petitions and cases has allowed many victims and their families to receive reparations. And I do explain this because we learned this earlier today. Don't want there to be misunderstanding. Reparations, compensation, or damages, or other reparatory orders which were made for the violation of their rights. It has also led to the implementation of important public policies to promote and protect human rights throughout the region, and also legislative changes. It is in the system of petitions that the Inter-American Commission of Human Rights has consolidated a line of work which issues recommendations for structural changes in the institutional, legal, and administrative frameworks of states. When states comply with Inter-American recommendations, they introduce institutional, legal, and social reforms, also helping to ensure the non-recurrence of violations by intervening in the context which allow them not to reoccur. One of the Commission's main protection mechanisms is the precautionary measures issued in grave situations. This mechanism has undoubtedly saved countless lives in recent decades by operating as an effective instrument of protection against possible serious and irreparable harm to individuals or groups of people facing situations of imminent risk. So the Commission deals with individuals, a singular individual, as well as groups, a village, a town, a community, and sometimes 1,200 people comprise a group. And we go through the whole spectrum. The Inter-American Commission's scope of action continues to evolve, also in terms of monitoring the human rights situation in the 35 OAS member states. Through the work of country and thematic rapporteurships, the Inter-American Commission produces a variety of documents which record the information received in its monitoring mechanism. These documents include thematic, country, and annual reports, and press releases. The Inter-American Commission of Human Rights currently has 13 thematic rapporteurships, which assume the task of leading the monitoring and development of the Inter-American standards. These 13 rapporteurships are assigned to or chosen by commissioners. The Commission also has 2 special rapporteurships on freedom of expression and economic, social, cultural, and environmental rights. This is the latest one. It has been in existence for 6 years, the latter. Freedom of expression has been there for many years. These special rapporteurships are headed by experts chosen by the Inter-American Commission through a public and open mechanism. The Commission has published 52 annual reports addressing aspects of human rights situation on the continent. And you can count, the Commission has been in existence for also over 60 years. 52 reports is pretty close that it started work in this regard quite early on. It has carried out more than 100 on-site visits, published about 80 country reports, and more than 100 thematic reports on the topics included in the mandate of the rapporteurships. It has held 189 sessions, granted approximately 2,500 hearings, and issued more than 2,500 press releases. In the area of technical cooperation, the Commission has signed agreements with a variety of institutions, including like you did, yes, and including other regional organs, final and international courts, universities, and academic organizations in order to conduct collaborative work. In addition, the Commission has provided technical assistance to member states, promoting structural changes to public policies which aim to comply with inter-American human rights standards. And as part of this cooperation mechanism, the Commission has published compilations and practical guides that provide member states with much needed guidance on different issues. We have recently assisted the member state with checking their drafts, 2 pieces of their draft legislation at the request of the state. As I mentioned before, in its more than 60 years, the Commission has played an important role in monitoring the situation of human rights in our region and has observed significant changes. In this sense, I would like to take a moment to briefly mention some progress that the Commission has observed in recent years, but also to highlight the challenges that countries in our region still face. As elucidated by the Inter-American Commission's annual report 2022, it is possible to mention that progress has been made in matters of human rights institutionality and public policies with a human rights approach. The adoption of national plans on human rights and to advance the rights of children, women, LGBTI persons, as well as Afro-descendants, and democratic participation of historically discriminated other groups. Regarding the rights of children, some states have adopted enhanced protection in judicial processes with the establishment of children-focused courts, for example. In relation to the rights of women, the Commission has noted the amendment and updating of domestic violence legislation and introduction of national sexual harassment laws and policies in several countries. In addition, the Commission has noted initiatives to promote access to humanitarian and specialized healthcare for Indigenous persons and specialized training of health professionals who work with these populations. The Commission has also taken note of several countries in the region have begun removing discriminatory colonial laws against LGBTI persons and others from their statute books, and guaranteeing the right to vote with respect to gender identity. Many advances in this regard have been noted in the Caribbean region, including where those colonial laws are being successfully challenged, for the most part, in the courts. However, the Americas, I should say, this region, still grapple with significant human rights challenges. The IACHR, the Commission, has observed actions coming from different branches of power which put democratic institutions at risk, and as a consequence, weaken judicial independence. We registered the weakening of national human rights institutions, the closure of democratic spaces, and obstacles to the exercise of journalistic work, as well as violence against human rights defenders and journalists, physical violence and harassment and intimidation against so many groups, professions, and peoples. We observed with concern the persistence of high levels of impunity in cases of human rights violations, with serious effects, such as the weakening of social trust in public institutions. The Commission has identified a greater frequency of recourse to the imposition of states of emergencies as a measure to address situations which affect citizen security, the intensification of militarization actions, and state actions aimed at repressing social protests through the disproportionate use of force. This situation of people deprived of liberty was also observed with special concern. Due to the prison crisis caused by serious conditions of detention, overcrowding, and excessive use of preventive detention, state abandonment of the prison system, the absence of criminal policies with a focus on human rights. All this we view with concern. The Commission followed up on the situation of people in human mobility or in need of international protection. We observed different crises, challenges. For example, the increase in displacement of Nicaraguans, the successive migratory movement of Haitians, and situations of risk and human insecurity at borders, particularly in the case of women and girls. The Commission recorded violations through immigration policies such as visa restrictions and processing of migrants for the crime of illegal entry. I ask you. These challenges underscore the pressing need for concerted efforts to address systemic inequalities, enhance legal protections, and promote inclusive policies which safeguard the fundamental rights of vulnerable and marginalized groups across our region. There are still large institutional gaps in terms of the adaptation of international standards to the domestic system. Factors such as political will, the capacity of state institutions to prevent and respond, the general public's knowledge of their human rights, and the strength of civil society are fundamental to achieving effective compliance with the obligations contained in the Inter-American instruments. In the construction of prosperous, peaceful, and just societies in the Americas, all human rights must be guaranteed without discrimination, with priority given without delay to actions aimed at combating poverty and inequality, as well as protecting the environment. Therefore, it is necessary to redouble efforts for the implementation of public policies with a human rights approach, which can generate real concrete impacts on the enjoyment of these rights. The Inter-American Commission's 6 decades of experience demonstrates that the advancement of human rights is achieved through a combination of efforts by it, by civil society, states, and the victims themselves. That is why spaces for debate and exchange of knowledge and experiences, such as this event, are of the utmost relevance. I am very pleased about this visit to Canada, and I'm very pleased to be able to share a little of the Commission's work and promote the Inter-American human rights system. Now it is up to all of us, to keep channels of dialogue open and seek the engagement of more peoples. On December 31st, I finished my 2nd term as commissioner and leave the Inter-American Commission of Human Rights after 8 years. But I want to ask you to look at the Inter-American system as a necessary, relevant, and effective regional mechanism, which the state of Canada has, since its membership, helped with its financial support and its engagement with the Commission to be the strong organ it is today. We have received some support, especially for women and children. But more, much more, can be done by Canada. For example, it can ratify the American Convention and others and present a candidate for the Commission. I thank you for your attention, but I want to say this, that we have been informed that the delay in ratifying the Lambda Para is due to the fact of the necessity for consultation with the provinces and territories, and that this takes inordinate time. Clearly it does. And I come to the question, is there the political will? Perhaps some of you can answer that. Thank you.
Thank you very much, Madam President, for your insightful presentation. And as you were speaking, and since we're talking about budgets, I was looking at the last annual report of the Inter-American Commission of Human Rights. The budget for 2022 was the ordinary funds given by the Organization of American States was of $11 million. In addition to the specific cooperation, its budget was of $8.5 million. So overall, they have under $20 million to promote, protect, and address human rights challenges and violations in all of the Americas, from Arctic to Antarctica. So that's pretty much 0.000005 pennies per capita or per person. So that is a challenge. And since we're mentioning about the possibility of the School of Law to actually grant some funds for the commission through internships, I have to say that at least three of the best legal professionals of the Inter-American Commission of Human Rights were Canadians, including one from our Faculty of Law. I will keep their names anonymous because I don't want to embarrass them in public. One, unfortunately, has sadly passed away a few years ago, but there is a role, and whoever is active in Canada regarding the system really is engaged with the system and usually uses that as one of the cornerstones of their professional career. So when President May was mentioning the issue of the petitions and the relationship, special relationship that the Commission has with civil society, is that it helps propel different topics that are not necessarily covered in their funding instruments. If you were to see the American Convention on Human Rights or the American Declaration on the Rights and Duties of Man, horrible name, I know, we need to change that. There is no element about gender-based violence. There's no language on that. But it has been the Commission, with the work of academics, with the work of civil society organizations, that has actually set a very straightforward and forward-thinking agenda to address and prevent gender-based violence. And I say this because it is our absolute pleasure to perhaps welcome one of the most prominent scholars in this field in our country, in Canada. I'm gonna get my passport soon, so I can actually now say our country, okay, not just Peruvian. So Dr. Amanda Dale, she obtained her PhD in Osgood Law School. She's specialized in gender justice and access to justice. She's a fellow of our Human Rights Research and Education Center, but is also the Director of Communications and Engagement of the Canadian Center for Legal Innovation and Sexual Assault Law. So Dr. Dale, you have the floor, and thank you for joining us tonight.
Well, thank you, Salvador. I think there are a few contenders for the titles you've bestowed me this evening. I sort of actually work in kind of a liminal space between academia and activism. And I'm speaking to you in response to the president's comments from that strange and sometimes disorienting space that I occupy. What to turn to in times like these, as John was mentioning at the beginning, when our values are being incinerated and whole swaths of populations before our very eyes are also being incinerated. When intergenerational injustice comes home to engulf, times of work feel gossamer and on the brink of extinction. For poetry, I find I frequently turn to competing notions of law and its role in aiding progressive change to understand my activist heart's experience of thwarted claims to equality and security before the law. Patricia Williams, the American scholar, has characterized black letter view of law as a skeleton devoid of flesh. She advocates instead for a view of the law as an embodiment of society, reflective of both its prejudice and its aspirations to justice. In that spirit, I want to briefly entertain three high-level interconnected questions that perplex me about this evening's discussion. I want to talk about some advantages and challenges of further engagement in the hemisphere with respect to women's human rights. I want to discuss what are some of the challenges and opportunities, the reasons that both John and the President have mentioned that Canada is reluctant to participate. And specifically about Canada ratifying Belém do Pará, as we have been called upon to do. And what are the current and pressing issues with respect to gender-based violence against women in Canada? Gender-based violence, of course, is both a human rights and a public health crisis of what the WHO has called pandemic proportions. Long before COVID, it was declared a pandemic. This affects and engages countries and populations globally. Canada is absolutely no exception, and in fact, in the top half of the statistics globally. Globally, as many as 38% of all murders of women are committed by intimate partners. And overall, 35% of women worldwide have experienced either physical and/or sexual intimate partner violence or non-partner sexual violence. And we know that those forms of violence are actually underreported. Intimate partner violence is the most common form of violence against women in Canada. For instance, with 8 in 10 victims who are women and girls. In 2017, 84% of police reported homicide victims were killed by an intimate partner were women. In 2021, I was the lead author of a report to the Canadian government that engaged 40 gender-based violence experts across the country. It's called Expert Engagement to Address and Prevent Gender-Based Violence. It's a thrilling title, I know. But to guide the implementation of a national action plan on violence against women and gender-based violence in Canada. We submitted it to the Ministry of Women and Gender Equality. In it, we called for the federal government to sign on to the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, known as the Convention of Belém-do Pará. The Convention of Belém-do Pará, where it was adopted in 1994, defines violence against women. It establishes the right of every woman to a life free of violence and says which human rights constitute this right to a life free of violence. It calls for the first time for the establishment of mechanisms for protecting and defending women's rights as essential to combating the phenomenon of violence against women's physical, sexual, and psychological integrity, whether in the public or the private sphere, and for asserting those rights within society. In other words, it takes a holistic and intersectional approach. The treaty has been translated into a number of languages spoken in the region, including a variety of Indigenous languages. The Inter-American Court of Human Rights has decided several cases based on this treaty, interpreting it as part of the human rights treaties of this system. When we wrote the paper, we said we were strongly of the opinion that signing a new set of obligations runs the risk of being performative unless we undertake to fulfill the obligation to promote both the state's and the public's understanding of its obligations. Some energizing international examples of how this can be done were offered and not taken up. Match this undertaking, we said, with appropriate investment in a consultative framework with monitoring capacity to follow up on all international human rights obligations that have both government machinery and civil society input. This has long been a topic of discussion in Canada. Plans and failed targets, as well as a clear call from various treaty bodies at the Universal Periodic Review, etc. We also said we must fulfill the relevant recommendations related to gender-based violence against women that Canada has yet to fulfill. This included having a national action plan, which we were calling for and which has now since been launched. Starting with the CEDAW country observations and the individual communications that have remained unfulfilled. In concert with these sincere efforts, where Canada invests in the machinery to implement its international human rights obligations and the norms associated with them, we agree that a session would be fantastic to support domestic efforts to eliminate violence against women, including the federal strategy to prevent and address gender-based violence, the implementation of the Missing and Murdered Indigenous Women and Girls National Action Plan, as well as the National Action Plan to End Gender-Based Violence. You have to understand, in Canada, we have many constituencies and never one way of addressing. We're a binational nation, so there are many ways in which these different plans need to be coordinated and need some oversight. Some of the challenges and opportunities specific to the possibility of Canada ratifying Belém-do Pará involve perceptions of what it entails. And I think we need to settle these for once and for all. Since we called for accession to Belém do Pará, the climate for women's rights in the hemisphere has deteriorated with some notable exceptions. There have been some successes on abortion, in fact, at the same time as there have been some serious slides. Some of the most restrictive abortion laws in the world have been advanced in the hemisphere, prohibiting abortion altogether and indeed criminalizing it. This is both reason to join in hemispheric human rights efforts and reason to be wary. Emboldened by the overturning of Roe v. Wade in the US, by their successes at restricting protections for LGBTQI people, and by implementing a wide variety of state laws that bring draconian prosecution of women and their bodies to new levels, we need to be vigilant about such efforts and effects here. Having closely watched the debate on gun control at the Senate over the last week, and I'm sure there was a vote this afternoon that I've missed, it is clear that even lawmakers here are not aware of the different legal frameworks between the well-funded lobbyists they hear from the US and our own system. A senator asked if it was not legal to openly carry arms in Canada. It's shocking to me. The links between the gun lobby and these other regressive movements against gender, for misogyny, and openly racist, in short, white supremacy, are being clearly revealed in current academic research, the links between all of those groups. These forces are plain to those of us who lived here throughout the occupation of Ottawa. And these are the conditions in which we are discussing introducing clarity about our human rights obligations. We understand anecdotally that advice had been given to the Canadian decision makers with respect to Article 4.1 of the IACHR, which defines life as beginning at conception and its potential to provide an avenue for interference with Canadian women's right to choose to have an abortion. That has been one of the huge stumbling blocks. I believe that a definitive finding on this would reassure and bolster efforts, and I'm hoping Salvador will write it. As for current protections and what Belém do Pará might add to them, there is a variety of legally binding instruments that oblige states to protect against gender-based violence that Canada is already party to. These are legally binding mechanisms that offer protections against GBV and have been instituted internationally, globally, and within regions, and in many cases applied outside of them. Many of these advances in law have been the result of the excellent work by women's advocates fighting for the recognition of the unique and intersecting harms inflicted on them. First and foremost, so-called mainstream Canadian feminists and Indigenous women who have been fighting for their rights have often relied on Canada's obligations under CEDAW. CEDAW and its jurisprudence, General Recommendation 19, and its update, General Recommendation number 35, the Declaration on the Elimination of Violence Against Women, constitutes a legally binding framework on violence against women as both a form of discrimination and as a standalone violation of human rights. This is underscored by Joint General Recommendation number 31 of the Committee on the Elimination of Discrimination Against Women and General Comment 18 of the Committee of the Rights of the Child on Harmful Practices. No state has opposed the 3 CEDAW general recommendations dealing directly with gender-based violence against women, nor any of the other general recommendations that touch on this topic. This normative framework has been recognized by all countries. Based on constant state practice, the committee has stated that the prohibition of gender-based violence against women has evolved into a principle of customary international law. I know this drives John crazy because they didn't do quite enough research to back this claim up, but it has moved forward as a standard of international customary law. This means that all states, even those who have not ratified CEDAW, are required by the agreed upon principles of international law to fulfill the obligation to protect women against gender-based violence. Protections against gender-based violence are also found in a variety of international human rights treaties under the protection against gender discrimination and the right to life, liberty, and security of the person. In relation to the protections offered under CEDAW, we can observe through the so-called individual communications or the individual cases brought to the treaty body from individuals claiming violation of their rights in Canada, certain patterns emerge. A nexus of Canadian public policy failures have been noted at the intersections of indigeneity, race, and gender-based violence against women. These failures have propelled both the recommendations arising from individual breaches and from the reports and result from Canada's regular reporting cycles. An examination of these reveals that there have been specific directives to Canada that remain unfulfilled. We highlighted these as recommendations in the National Action Plan itself. CEDAW and the UN Special Rapporteur on Violence Against Women have also been at pains to point out Canada's obligation to advance and promote both the states and the public's understanding of its obligations under CEDAW. That is, international human rights education is a critical aspect of its obligation to prevent, protect, and fulfill. So why consider another treaty? Does more law make us more likely to do the work of fulfilling? To me, there is a tremendous organizing potential in embracing a new campaign of human rights renewal in the region. Education, engagement, and yes, accessible quasi-judicial implementation support. What are the current pressing issues with respect to gender-based violence in Canada that we might address through this? It is impossible to speak of gender-based violence in Canada without attending to the massive crisis in human rights of missing and murdered Indigenous women and girls. Canada is at a crossroads when it comes to violence against women and gender-based violence. There has been a perfect storm of colliding pandemics. COVID-19, which locked women up with their abusers, missing and murdered Indigenous women and girls, and the pre-existing WHO-declared pandemic of gender-based violence. This created both the conditions for escalating harms and an aperture for real change. The driving question in what, it must be said, has been historic levels of funding and attention to gender-based violence in the 40 years that I've been doing this work, is accountability. Does anything change on the ground from all of the efforts that are launched, funded, and then later defunded? What coordination is possible between levels of government in a hostile and polarized political environment? In a context that yesterday Cindy Blackstock called change resistant. Ironically, the federal government has the least jurisdiction in most matters that impact on gender-based violence, save criminal law, federal policing, the Divorce Act, although it must be said more could be done with the Canada Health Act, but that's another discussion. In our submission to Women and Gender Equality, we worked with a compendium of 646 recommendations that had been issued on this matter. We collected and shared them, and then we updated them and reduced them. To the death of 21 people in Portapique, Nova Scotia, which was widely agreed to have been perpetrated by misogynist impulse, the Mass Casualty Commission, which itself was a result of activist insistence on a public process, they reported in their volume 3 on violence, recognizing that ending gender-based violence requires sustained collective action, which they referred to as a whole of society response. They recommended a national accountability framework led by a federal gender-based violence commissioner with effective powers. The commissioner's mandate would be developed in consultation with governments, women, survivors, and the gender-based violence advocacy and support sector. The mandate would include such initiatives as coordinated monitoring and evaluation, an advisory committee, evidence-based policy reform, and the promotion of knowledge sharing. They conclude that this accountability mechanism must be national, independent, impartial, supported by legislation, and have strong powers. They recommend the creation of the Office of Independent Commissioner with a staff for this purpose. They provisionally name this function the Gender-Based Violence Commissioner. Designating any accountability mechanism should be answering the question, what are the real accountability problems we want to address? In the case of gender-based violence and interpersonal violence are at epidemic levels. There's a femicide every 2.5 days. A woman or girl is killed by a man she knows. Every 6 days, a woman is killed by her intimate partner. These are Canadian statistics. The Canadian experience of gender-based violence is affected and made more deadly by other forms of human rights violations, discrimination and marginalization with which gender discrimination intersects, with particular risks for Indigenous women. Canada's National Action Plan has been announced and federally funded. There have been commitments from other levels of government, according to existing platforms, mandates, and commitments already made. Provincial agreements with funding attached are in process at the time of writing, and accountability for these agreements is completely unclear. Some Indigenous women leaders working on the calls to justice, particularly recommendation 1.7, which was the call for the National Indigenous and Human Rights Ombudsperson, have taught us that innovative structures of accountability can be imagined that include specific content expertise on gender-based violence and community-based accountability and expertise that includes survivor experiences and reality checks on what has been implemented and what is being contemplated as part of responding to ongoing and structural human rights violations in society. Can the Inter-American Human Rights Commission and Belém do Pará specifically help us monitor the implementation of monitoring? To be meta, in an article exploring labor rights in Canada, Faye Faraday and Eric Tucker asked the question, who owns charter values? I believe we should ask the same question about human rights more generally and seize the opportunity to engage, educate, and change not just the laws, but the social context of human rights, prevention, protection, and fulfillment. Could engagement with the Inter-American Human Rights Commission launch such a regeneration through low barrier access, hemispheric collaboration, and ongoing accountability? Let's find out.
Thank you very much, Dr. Dale, for this very powerful comment on the possibilities that Canada could use by being more engaged and be a party of specific instruments within the Inter-American human rights system. Also, when we talk about Canada and human rights, speaking abroad, there is one term that comes to mind. It is business and human rights. Canada is a global powerhouse in the extractive industry, and they have specific interests, geostrategic interests worldwide, especially in Latin America. Just like in gender-based violence, there is not a single word about business and human rights in any instruments of the Inter-American human rights system, but it has been through the power of organizations, indigenous peoples, academics, that have focused on the issue of business and human rights, not only locally, because there are business and human rights issues here at home with First Nations. There are a lot of territorial disputes within First Nations and public authorities, but also what is the role, or is there a role of Canada to assure that Canadian companies operating abroad to address and to prevent or mitigate human rights abuses that are happening, or let me just rephrase that, violate, because that is the language used by the Inter-American system, when this happens on Indigenous peoples or other groups. So to try to address these topics and the challenges that we have here at home, it is my absolute pleasure to again welcome Professor Penelope Simons. She's a full professor of the Faculty of Law of our university and the Gordon Henderson Chair of Human Rights of our Human Rights Research and Education Center. Professor Simons, welcome, and you have the floor.
Just got some new glasses, so I'm trying to figure out which ones are better to see. I think it might be these. Just hold this up. Thank you, and President May, thank you so much for visiting us with your delegation and coming to Canada. It's very important for us to have you here, and I want to ask you to help us nudge Canada towards doing something better to regulate its extractive companies operating abroad. As many people know, Canadian extractive companies have been involved in grave violations of human rights when they're in their overseas operations, and particularly in Latin America. And that has included, grave instances of gender-based violence as well, and racist violence as well, and violence against human rights defenders. And Canada has obligations, human rights obligations, even though it hasn't ratified the Inter-American Convention on Human Rights. It has human rights obligations under the United Nations Conventions to protect human rights. And this means that it should be taking steps to prevent private actors, such as businesses and enterprises, from violating or becoming complicit in violations of human rights. And this includes an obligation to take appropriate legislative and other measures in relation to all activities that are taking place in whole or in part in Canada's territory and jurisdiction that have a direct and reasonably foreseeable impact on the human rights of individuals or groups in other states, including those by corporate entities that are based in Canada or subject to Canada's jurisdiction. And then, if there have been violations, then Canada has to investigate and provide effective remedies for those. So our biggest problem is that Canada has continued to take a policy-based approach to regulating Canadian companies. And even though there have been almost over 2 decades of activism, there's been over 2 decades of activism and calls from parliamentary committees, United Nations treaty bodies, hearings at the Inter-American Commission of Human Rights on Canada's extractive industries, Canada has continued to rely on policy as opposed to legislation to regulate its companies. And in April of 2022, a few days after a few private members' bills were tabled that put forward legislation that I'll talk about in a second that could have regulated Canadian companies operating abroad, the government's introduced a new strategy called Responsible Business Conduct Abroad, Canada's Strategy for the Future. And I'm hoping it's not for a long future. So the strategy is an improvement on previous strategies that the Canadian government has had. It makes due diligence a core component of Canada's approach to responsible business conduct. So Canadian companies are expected to identify, prevent, and mitigate and account for how they address actual and potential adverse impacts of their operations and in their supply chains and relationships. And they're also supposed to develop policies and management systems to support due diligence and potential actual negative impacts on communities and environments. Now, these are much clearer expectations because they certainly weren't there in the previous 2 strategies that had been brought in by the previous regime. prior to the Trudeau government coming in. But the strategy relies on voluntary self-regulation, essentially, and it has a few what we would call reflexive mechanisms to try and incentivize companies to follow the prescriptions, such as making certain attestations on integrity, the integrity of what they're doing, in order to gain support of the Trade Commissioner's service, and the threat that this service will be taken away, withdrawn if businesses fail to comply with Canada's responsible business conduct laws, policies, and standards. Now, there are various problems with these attestations, and I don't really want to spend time discussing them, but I'm happy to talk about them afterwards if we have time for questions. But at its base, it continues this voluntary self-regulatory approach. And the idea is that by making these attestations, it's hoped that companies are going to start thinking about what they're doing and maybe have a crisis of conscience and make sure that they don't violate human rights abroad or engage in environmental harm. And we know very well that voluntary self-regulation has long been ineffective, or I wouldn't be standing here today saying all of this, because that's what we've been doing for years and years and years. And this failure has been recognized by many states. There are states in Europe now that are introducing legislation to require companies to engage in human rights due diligence, to take steps to prevent and if not prevent, then to mitigate their impacts and then to redress those impacts and providing some sort of remedy. So I want to talk about what Canada has done in terms of legislation too. They have, because there is this sort of narrative out there that they are taking steps, that they have introduced legislation. They've introduced a bill or an act that will come into force in early January, I think, and it's called the Act to Enact the Fighting Against Forced Labor and Child Labor in Supply Chains and to amend the Customs Tariff. And what this is it's modeled on the Australian and the British modern slavery bills that require companies not to take steps to engage in human rights due diligence to ensure that they're not, that they don't have forced labor in their supply chains, or they're not doing business where there's child labor involved. What it does is it requires companies to report on what they have done, if they've done anything to eradicate child labor in their supply chains. So they have to report on the steps they have taken during the previous financial year to prevent or reduce the risk of forced labor or child labor. And the report has to include things like the company's policies, the due diligence processes they have in place, et cetera, if they have any. So it's possible, and it has been shown in Australia and the UK, that they can just not report. They will report on that they haven't taken any steps. And it's only where the company fails to report or make a report public that this can incur a fine of $250,000 for the failure to report. So like the attestations and declarations, it's a reflexive mechanism rather than a prescriptive mechanism asking companies to engage in human rights due diligence. And so it has very little that will, I guess, allow, enforce or push companies to stop violating human rights. And also the other problem is it's very focused on forced labor and child labor only, and not the wide variety of human rights violations that companies can become complicit in or they can commit. Now, there is a bill that I mentioned before that was tabled. It's a private member's bill that was tabled by an NDP member, Peter Julian, back in March of 2022. And if enacted into law, it would impose a duty on companies to avoid causing or contributing to adverse, this language of adverse human rights impacts is a bit problematic, but say human rights violations abroad by entities or within their corporate group or through their business relationships. And it would impose liability for harm caused through that failure to comply with this duty to engage in human rights due diligence. It would also do two other things. It would create a private cause of action for those who had suffered harm because the company had failed to meet its duty to prevent these adverse impacts, and another cause of action for certain persons to bring a claim against a company for failing to develop due diligence procedures. So far, this bill has not had any government uptake, and it's just sitting there. And as I said, that new policy that came out was enacted and was tabled a month after this was tabled. So it's been very disappointing. The third thing I wanted to briefly mention was that Canada has also taken steps to establish what it considers a unique human rights complaint mechanism for business activity abroad. So to deal with complaints that come in from people who've been affected by Canadian companies. It's restricted to extractive companies and garment companies. Now, non-judicial remedies like this ombudsperson that has been established play an important role in ensuring the right to an effective remedy, because the right to an effective remedy cannot only be the ability to bring cases in court. But the CORE was established, and it was supposed to have powers to compel witnesses and documents. So it was supposed to then have teeth that would make sure that when the ombudsperson was going to investigate a complaint, she would be able to compel the company to testify and members of the company to testify, and also to provide documentation. But when the government established this, they did not give this person the powers to do this. And so now we have spent a lot of money, millions of dollars. She has a budget. There are 20 complaints that have gone forward to the Canadian Ombudsman for Responsible Enterprise, the CORE, and nothing has yet, not one complaint has been decided finally. I think one was withdrawn because it was apparently resolved. It was resolved for the person who made the complaint, but the other ones have not yet been decided, and it was set up in 2019. So it's moving at a glacial pace, but also we don't know if they're going to be able to do credible investigations, because the companies really don't have to appear before the commissioner and give evidence. So what we need help with is nudging Canada towards, first of all, adopting human rights due diligence legislation. And there is a second bill before Parliament that, if adopted, would give the powers that I've just talked about to the Canadian Ombudsman for Responsible Enterprise. And I think both of these, while they're just first steps, they would help to move Canada closer to compliance with its obligations to protect human rights and to provide effective remedies. And I think it's in the interest also of the inter-American system for this to happen. And so I would ask for your support. Now, just one last thing I'll say is that there is an opening, because the mandate letter that was given to the Minister of Labor asked the Minister of Labor, who was supposed to work with the support of two other ministers, to introduce legislation on forced labor to eradicate forced labor from Canadian supply chains, but also to ensure that Canadian businesses operating abroad do not contribute to human rights abuses. So they haven't even done the first part properly, because the reporting bill is not going to eradicate forced labor in supply chains. But that second sentence is very important and could be used to push them to, with a little nudge, they could get there and perhaps maybe adopt or bring in their own bills that are similar to the ones that are private members' bills that have been tabled. So thank you very much.
Thank you very much, Professor Simons, for your words. We are coming close to 6:30. We're going to try to end at that time, especially see some students that you should be studying for your final exams. So thank you for being here. I will open the round for a couple of two brief questions, but based on what Dr. Dale mentioned, I think that it is a very important question regarding the interpretation of the right to life under the American Convention on Human Rights. does the Article 4 of the American Convention prohibit or could limit the access to abortion? This is perhaps, Commissioner May, something that we could perhaps discuss a bit more, no? And secondly, the importance, perhaps the inter-American system has done, or better yet, the inter-American system has done so much for the business and human rights field. Because if you look at the provisions of the UN guiding principles, all of them are pretty much rights established within the American Convention and the American Declaration. So as states are being reluctant to adopt serious legislation that can actually address these violations, how do you see the role of the Commission could be in working with states, and especially global powerhouses in certain fields like Canada? So I would like to, if I may, leave these two first questions open, but also would like to give the floor to our distinguished audience for a couple of questions, and then we would give the floor to Madam Commissioner May, then to Dr. Dale, and then to Professor Simons. So anybody? I see John raising your hand. We'll start with John, and we'll take it from John, please.
I have a very brief question for President Macaulay. But first of all, I will just say about this issue, about 20 years ago, Lloyd Axworthy, or whenever he was in government, he was my member of parliament. And I wrote him a letter on it. And I said, what the heck is the problem with ratifying the convention? He was very pro-human rights. And he wrote back the long letter, and this was a principal argument. And I have a very simple response to it. If that's your concern, place an interpretive declaration or reservation on your instrument of ratification, and you're done. So this is a nonsense point. You are not bound. He had actually argued, clearly someone in the bureaucracy wrote, that it was going to cause Canada to fall below our standards. There is nothing in international law that requires you to bind yourself below your own standards. So this is a nonsense point, in my view. I was going to ask about democracy. Last time we met, we were in Zimbabwe for the Commonwealth Observation Commission. You recall they've had another election since, and the same guys are in power. But anyway, I want to ask about democracy. Because I don't know if I ever told you that one of the persons in the world who inspired me a long time ago, 45 years ago, was Michael Manley. And he did a speaking tour of Canada when I was a university student. And his words about the legacy of colonialism and the impact on that and how it hamstrung, at that time, developing countries, and your country including. But now we're living in a period where democracy is clearly under attack. And I wonder if you have, at the end of your presidency in the commission, but also having been a judge for so many years, if you have some reflections on what can we do about democracy.
Thank you very much, John.
Yes, I think it's on, yes?
Yes.
Yeah. I hope what was your first question about?
Right to life,
right to life,
access to abortion.
But I in my opinion, so the court has dealt with it, and dealt with it quite clearly and succinctly, and has made the position clear that the life does not start as it is worded in the convention, but women have the right to decide how their bodies would be used, the time of pregnancy, whether they would retain the pregnancy or not. And it is, and families, because there's that. And if you remember the case of, I forget the name, no, IVF versus Costa Rica. A great deal of the arguments that went on in that case had to deal with that interpretation of it. And the court, we made clear that no, we cannot be time-bound, and the human rights of women and persons and cannot be time-bound by such a narrow, confining interpretation. So as far as I'm concerned, I have always believed that the court has effectively dealt with it. And I am surprised when some states bring up the question again, and which indicates that some of the states which are members of the OAS are not cognizant of their obligations regarding the standards which are set and set as standards of the system and for the region. And I think ultimately they will have to abide by that, because you cannot overturn a decision of the court. So, I think it's a very strong system, and it will survive, and its standards will survive, even though they come under attack so often when certain regimes are in power. And these regimes, hopefully, come to democracy, hopefully will only be in power for the legal length of time. And we have seen examples of countries following democratic principles and policies and standards and steps and so on in institutionality, when the head of the state wants to extend their stay, they have been defeated. So you have those, and then you have the Nicaraguan situation or Venezuelan and so on. I suppose so that there is a balance, and they themselves cannot be there forever, because life is not infinite. They must die sometime. You know.
And in the field of business and human rights, what Canada can expect?
Well, I thank you, George. He knows when I get to the stage of the evening, I'm really exhausted, unless I have a glass of wine.
That can be a
Yes. George has reminded me that we published in 2020 Business and Human Rights Inter-American Standards, a publication which identified the international obligations of states with regard to human rights in cases in which business are in some way involved in the violation of such rights. And it is true. And I have to say this, that I remember, and so anybody can correct me if my memory is one of hope rather than clear memory, that Trudeau said when there were a number of cases coming into the system on violations of rights, and the companies, Canadian companies, especially mining companies, but also farming as well, that Canada was going to pass legislation to ensure that companies effectively live up to their obligation to also protect the rights of the peoples in the countries where they have their businesses. And I think too often we forget to remind politicians of what they say, because we know sometimes they make statements in public and it's a political statement, quotation marks, and they move on and forget that they've done so. Well, when I was a member of the NGO groups on the rights of women, I always, when I'm in the audience, I don't care if I'm way at the back, I would yell out to them. I said, remember, you said so and so and so and so, you cannot renege from it. Otherwise, you shouldn't be where you are. And it's sometimes effective. and if anything is sometimes effective, we have to try. One thing is that we cannot give up on any of these rights. We have to keep on and on and on until they get tired or they die or they get out or we're voted out. So, you know, we have to do that.
Thank you very much.
I wanted to say something that I mentioned Canada's generosity. They have been, but could be much more. But because we do receive voluntary funds from other states as well. But I've said it specifically because I was rapporteur of women's rights for 6 years, and then I got maybe stale on, handed it for 2 years to another commissioner. And throughout my period, Canada supported projects for women and children's rights and women's sexual reproductive rights specifically, which was unpopular with some of the states within the system. And so I do honor Canada for standing by that and continuing with it, in fact, even until today. Yes. So, thank you.
Thank you very much. Amanda, please.
What did you want me to respond to?
Invitation about vino somewhere. So
yeah, wine. Okay, red or white or pink.
Based on the challenges of gender-based violence on the Belén do Pará, we see forms of cooperation with the commission. We need to strengthen, I think, is one of the challenges between academics, civil society in Canada with the Inter-American Commission. Strengthen this. Do you see a venue of cooperation and the need to work with a specific agenda of the Belén do Pará, hopefully for a positive decision on the Beatriz versus El Salvador sometime next year, right? And how do you see hope when we meet someone from the commission again in next year, hopefully with better news? Exactly, yes.
Yeah, I mean, I think this has sparked the beginning of conversations with CSOs, NGOs that didn't know that this mechanism existed, that it had access points. So yesterday we had a discussion with a group of CSOs and NGOs who I think have gone away with new information. Yeah. And, you know, this is maybe too granular, but I think, you know, we're also talking about a collaboration with the Women's Human Rights Institute, which, you know, was founded by Alda Facio, also active in the region and a former judge. I say, why not make a specific aspect of that collaboration focus on the protections possible in the inter-American system for gender-based violence? Whether it's part of, and because the people who come to those institutes are generally the leaders, women's advocates, et cetera. And if we're holding such a session at the University of Ottawa, it's obvious that Canadian leaders will be, you know, proximate and might come, often do come. We used to hold it at the University of Toronto years and years and years ago. And often, you know, there's a global student base, but there's also the domestic student base. So I think we can use things that we're already doing. As my mother from Southern Saskatchewan used to say, bake 2 pies with 1 filling. So I think we can do that. That's, you know, that's one obvious way. I think writing more about it as well, so that it's accessible. You know, there's this global initiative for the Every Woman Treaty, which thankfully has abandoned the idea of a separate treaty now. Just on a misreading of international human rights law, which, you know, I've already explained, has evolved to a state where gender-based violence is a protection. There was this American initiative to create a whole new treaty called the Every Woman Treaty. And in one of my many rants about the foolishness of this activity, I talked about Belém do Pará and about Trudeau's announcement that there would be a sign-on from Canada. This seems to me a good redirection of some of the energy that has gone into this notion of a separate treaty at the international level. They have now abandoned the idea of a separate treaty, and they're going for an optional protocol to CEDAW, which to me is equally inane. and a waste of energy, and potentially undermines the already clear global compact on this. Because if you don't sign it, does that mean you don't agree? Does that undermine the agreement that's already created by the jurisprudence of CEDAW, et cetera? So is there a way to redirect some of that momentum into a conversation of Belém de Par, at least from Canada's side? So these are some of the opportunities I see to structurally shift the absence of information about the context of the inter-American system.
Thank you very much. Professor Simons?
Oh, sorry. Okay, thank you. What was the question?
Not on wine, not on wine.
Not on wine, okay. Usually rosé.
Yeah.
Or
mezcal, no.
Yeah.
Just about the business, also the opportunities of cooperation. Because
yes.
We would like to set, not only with Commissioner May, but also with her team here that is here, the next era of collaboration between us, Canadian academia, civil society, and the Commission on different fields, especially business and human rights.
Yeah. So I guess, yeah, this is an opportunity for us to think about, first of all, trying to get, looking for windows of opportunity to push Canada again. And there might be some, as I mentioned before. But I also think that we need to also expand beyond our thinking beyond extractives as well. We need to think about all the other things like agriculture you mentioned, for example, where, Canadian companies, for example, or other companies are involved. I think we should be talking about pushing all countries to participate in the Business and Human Rights Treaty as well that's being negotiated. And maybe even thinking of what about a regional Business and Human Rights Treaty? Something that the OAS states could get on board with as well. But I think definitely, on the issue of business and human rights, we need to, and we also need to think about moving beyond this concept of human rights due diligence. Human rights due diligence is a first step, but it isn't comprehensive enough to cover what needs to be done and how to hold companies accountable. We need much broader kind of legislation that, requires companies to take other steps and engage in reporting. We need perhaps to bring in stock exchanges and their listing requirements. We need to think about criminal sanctions for the very worst violations of human rights, those that might be committed in the context of conflict or war, those that, gender-based violence in certain situations, where it's gang rape, Canadian companies have been involved in that. And so I think we need to change that and also think about how we could change the concept of the corporation from these corporate structures that are groups of separate legal entities that are supposedly all acting independently when we know in fact they're acting as enterprises. So I think we just have to think beyond what's going on now in terms of business and human rights due diligence, and that's a good first step. And then remedies as well, like courts have to be able to bring hear these cases. They have to, so pushing states to provide effective remedies in their courts and also through non-judicial grievance mechanisms that are effective, not like what we have now, but what we hope to have at some point when they give the core powers.
There's something that I thought of, and this is what steps can we take now with this visit having become a reality? And this is for, I would ask all of you here and those on all the parties online, that each and every one of us, we have a duty to not only know what the rights are, what institutions exist, but actively engage in being a watchdog for your government. You have to be the watchdog to watch what they do, what they say, and use it to push and lobby for the adherence to the standards which have been established for respect of all human rights. And if we, the people, we do not do it, you cannot expect the politicians to do it by themselves. They will not do it. So every single one of us must act. And one of the things I thought of when I think you were speaking earlier is that in relation to Belém do Pará and the promised ratification, which is getting older by the day, and that we, the Commission, can, in fact, in a press release, deal with the issue of Canada and its statements in relation to ratifying the update. And if you can help us here by directing us attention of statements which were made when they were made, what was said, that will assist us to do such a press release. And in relation to other issues as well. And remember, please, that every single one of you, you can just write to the Commission an email. You can address it to, say, for instance, it's a women's rights issue. You can address it to the Rapporteur for the Rights of Women and say any fact that has come within your knowledge, which is a violation, or even a success story for Canada. All these are news that we can use and publish. And that helps not only Canada, but also other states in the region. And so I really do ask you to commit to that, please. And in relation to businesses, it is the political will which we need. Because in Peru, we had here when the states would collaborate with the companies against the citizen. Because, for instance, they were permitted at one time, I remember questioning the state on this issue, they would permit police officers to enter private contracts with companies for security, and they would shoot and injure and kill Peruvians. Now, this, and of course, there was impunity in almost all these matters. So it's the political will we need, and we have to push the states to act and really meet their obligation, which is serious obligation. Most of them, they've signed to it in Latin America. And they have to read it. And we just have to keep on speaking out. Don't be silent, and don't wait to have a glass of wine like me.
Thank you very much, everybody. We have come to the end of today's session. First of all, I would like to thank our translation team. Thank you very much for your service. Also to our audience for being here despite you're doing exams and other not so fun activities. To our members of the Inter-American Commission, and we wish you a nice weather for the remainder of your visit here in Canada so that the freezing cold doesn't get here until Friday when you leave. You have a Mexican and a Brazilian in your delegation. 15 degrees Celsius, they're already freezing cold. So you gotta work with them. I would also like to say that this is their last activity of the year of our Human Rights Research and Education Center. It has been quite an active season. We've had the High Commissioner of Human Rights here, among other illustrious academic and members of international organizations. And we close here with the presence of the president of the Inter-American Commission on Human Rights. It's also been a pleasure to always have Professor Penelope Simons and Dr. Amanda Dale with us. So to everybody, thank you very much. Muchas gracias and happy holidays.